Greg, you really created something here, and we all ought to take a bow to you for what you've done and created. My words tonight are from the heart. I'm indeed honored to be here tonight to honor the memory of a very distinguished American, a man whose work will live long in our history. Robert Jackson is remembered today as a Supreme Court justice and the father of the Nuremberg trials. Yet the road he took to becoming one of the most influential men in America and international law was not a traditional one. In many ways, Jackson is the embodiment of the American dream. As you know, he is educated right here in this area, and with only a high school education plus some study at Albany Law School, he entered the legal profession, apprenticing under local lawyers, where he tried cases in bars and town halls. It was still acceptable at that time to learn law this way. But when Jackson was appointed to the Supreme Court, he was the only justice at that time who had not graduated from law school or even college. Instead, he spent 2 decades practicing law locally in Western New York before moving to Washington, D.C., when Franklin Roosevelt was elected president. Jackson's rise from a local country lawyer to the top of his field was based on merit, not knowing the right people, not by having his ticket punched at the right times in his career. Robert Jackson was his own person. I knew this firsthand. Jackson's closing statement was delivered on July 26, 1946. I was asked to prepare a small section of it dealing with the German military. As it turned out, I stayed up all night during doing this, and I was very proud of what I had produced. The day after my all-night stint, I rushed to the press room to see whether any of my words had been used in the final document. When I saw the closing statement in final form, on close examination, I found that none of my words were used, although perhaps in 1 or 2 instances, my ideas were used in the final draft. In checking around with others after this episode, I found that Jackson did not believe in ghosts. If he were to speak, the words must be his own and not those of another. And I would note in passing that his speeches were indeed distinctively memorable and that they contained phrases which I believe will live forever. Robert Jackson, I believe, always liked Rudyard Kipling. And I think that Kipling's maxim, quote, "He travels fastest who travels alone," end of quote, was his guiding light. Robert Jackson's work is history. Its inheritance is with us today in many spheres of international life. Universal Declaration on Human Rights is with us in inheritance at Nuremberg, as are the Genocide Convention, Torture Convention, the European Convention on Human Rights. They are part of this world in which we live, and part of inheritance from Jackson. But there's one blot on Jackson's memory which needs attention in this country. At Nuremberg, Jackson said, quote, "As we pass a poisoned chalice to the lips of these defendants, we pass it to our lips as well," end of quote. This meant that those nations who brought the Nuremberg proceedings and adopted the Nuremberg principles were to abide by these principles themselves. This has been the case with the British and French, but not with the United States. I think that nations of the world should, by treaty, renounce aggression through a non-aggression pact. I hope that if aggression is precisely defined in such a pact, that the signatories would feel it in their interest to abide by it. To sum up, we now have war crimes courts in operation, deriving from Jackson, covering the former Yugoslavia, Rwanda, Iraq, and Sierra Leone, as well as the International Criminal Court at Hague, enforcing the principles Jackson enumerated at Nuremberg. We also have the prospect of other trials in the future, such as that projected for Cambodia. Judging based on what has occurred to date, it is a fair statement that Jackson's impact will grow significantly in the future, and the world will be better for it. Jackson summarized what he did at Nuremberg in a few words, quote, "This is the first case I have ever tried where I had to persuade others that a court should be established, help negotiate its establishment, and when that was done, not only to prepare my case, but to find a courtroom in which to try it," end of quote. In a nutshell, this summarizes what Jackson accomplished at Nuremberg. And when all is said and done, Nuremberg was the most important trial in history. Jackson's qualities of vision, fairness, courage were unique, and in fact, Nuremberg would never become a reality without the thrust they gave him to pursue a better world. We owe him and Warren County a deep debt of gratitude for all he did in pursuit of a better world, where law and justice would be the order of the day. May we long remember Robert Jackson and his magnificent achievements. Thank you.
You know, Henry King spoke last year. Henry King had some advantages over me. He was a fellow prosecutor at Nuremberg. He, of course, was able to give firsthand accounts of Nuremberg, firsthand accounts of Justice Jackson. You're not going to get any firsthand accounts from me today. Justice Jackson died suddenly in 1954, and I was born not so suddenly in 1960. So Chief Justice Rehnquist, who clerked for Jackson, I think in about 1951 and 52, wrote an article about the justice, and he made the points I just made and said Jackson in many ways is a lot like a Lincoln. And that people don't, even Greg doesn't compare people to Lincoln very easily. But I'm going to do that, and I'm going to take Chief Justice Rehnquist a couple steps further. So you have the obvious things: no education, self-educated, they're both country lawyers. They both had great senses of humor. They were both terrific storytellers throughout their lives. They always had this kind of common sense and common touch that never left them, no matter how successful they were. They became great writers. So there really is something there. The two things, though, that I like the most about thinking about Lincoln versus Jackson, or Lincoln and Jackson, is one, I think they both thought by writing. Most people, when they write, they think first, they make some notes, then they write. I think for both of them, the act of thinking was the act of writing, and the two went together. Probably explains why they were such effective writers. There's a book, if you're interested in the point I'm making, I think it's called Lincoln's Sword, which came out in the last year or two, and it makes the point that Lincoln's most effective weapon was his pen. And in doing that, it elaborates on the notion that every time Lincoln had to wrestle with a problem, whether it was when to give the Gettysburg Address, when to do the Emancipation Proclamation, the second inaugural, he worked through these things through writing. Jackson was the same way. I've not heard of any other justice, much less a judge, that had this habit. He would write draft opinions before oral argument. Now, as a judge, I can tell you that's just extraordinary and, to my mind, stupid. The reason I think it's stupid is you don't know that you're going to be assigned the case. There are 9 justices on the Supreme Court, and why in the world you'd write an opinion before argument when you might not get the case assignment is really hard for me to fathom, except if that's the way you think. And that clearly was part of Jackson's way. The other comparison that intrigues me is obviously Lincoln and Jackson had this. They did have this natural talent, Springfield, Warren, whatever it was, the water. And they also had ambition. I mean, you have to be ambitious to do what they did. But most people with talent and ambition that succeed, they follow the madding crowd. So they do what those above them do, and once they get there, they continue to be fairly conventional. Not true with Lincoln and Jackson. They remained individuals throughout. That kind of country lawyer, common sense, common touch never eluded them. And, it's extraordinary. And I guess it proves that they were both loyal to their roots and they never forgot where they came from. For Jackson, the best illustration of that is his opinion in the steel seizures case. That's the case in which Harry Truman tried to seize the steel mills to preempt a Union strike during the Korean War. And Jackson was not assigned the opinion. As you now know, he already had written one. But he was not assigned the opinion. The opinion went to Justice Black. And Justice Jackson, the individual that he was, still felt a need to write separately why he was concurring. He was still agreeing with Justice Black. And that opinion, the concurrence, has become the model for all Supreme Court opinions and all debates about what kind of executive branch power a president has and what kind of power he does not have. Well, how do you describe everyone who gets in the Supreme Court is fairly smart. Some would say very smart. And once they're there, they're writing for history. So they're all trying to write Jackson-like opinions. Why does Jackson write them but the others don't? And I think it's the country lawyer in him. That to me, it was the common sense, the common touch, the pragmatism that was not doctrinaire. It was not about the Washington rules. He learned how to survive and thrive in Washington, that's for sure. But he didn't lose that, and that's his legacy, which is exciting. Conclusion. Agatha Christie, I'm told, was married to an archaeologist, and she liked to say she loved being married to an archaeologist because the older she got, the more interested in her spouse became. So Justice Jackson is our Agatha Christie. The older he gets, the more interested in him we become. And so why is that? A couple reasons. Well, Warren County, it's quite natural. It's never going to stop. But it's not just Warren County. It's among the bar. Even before I knew Justice Jackson was from Warren County, I knew about his opinions and knew how well done they were and had a high regard for him. So what exactly is going on there? Some of it is that he was fortunate. He was a justice during this transformative period that was just so critical in Supreme Court history. He was there when they were deciding some just critical cases for establishing the role of the court in American history. And then he had the good fortune either of writing the majority opinions in those cases or concurrences. And then you add to it that he wrote like no other. And I think that really helps to explain the legacy. The other point is at the court, there's really one debate when it comes to constitutional cases. And that debate is always conflicts between liberty, order, the individual versus government. And in Supreme Court history, you get justices that incline one side or the other. And what was so terrific about Jackson, and I think reflected his roots and reflected this common touch, pragmatic approach to the law, was that he never always ended up on one side. One day he would be with the government, the next day he wouldn't. And so I think he was always very good and very effective at trying to figure out that exact balance between liberty and order, the government and the individual. And so I think that's why he's well known today, that's why he's revered today, but I think that's why 50 years from now that will still be true. He said once that about Washington, which I don't know that he ever cared for. I think he loved it while he was having such tremendous success as general counsel of the IRS, head of the antitrust division, head of the tax division, attorney general, solicitor general. I mean, that had to be pretty exciting, just one step up after the other. and then finally being a justice. But by the time I think he was a justice, I think he saw a side of Washington that was a little less flattering, perhaps shown by the Nuremberg black experience. He said once that Washington, for a public official, Washington takes everything and gives nothing. Well, I think what he would say about Warren County, it was that it gave everything and it asked nothing in return. I really enjoyed being back in Warren, being able to see my family and see all of you in this wonderful, very impressive courtroom.
Thank you.
The program that I put together in 2002, I filmed an interview with Chief Justice Rehnquist, and that was a really unique opportunity, obviously.
Good afternoon, Chief Justice Rehnquist. On behalf of everyone assembled at Duquesne University in Pittsburgh, as well as the Harry S. Truman Presidential Museum and Library that's co-sponsoring this event, I'd like to thank you for participating in this special program. I have just a few questions to set the stage as we begin this retrospective, looking back 50 years in history. You were just a 27-year-old law clerk, clerking for Justice Jackson, only a few months in Washington at the time the steel seizure case landed in the courts. At the time, was this a case everyone expected would be a constitutional landmark? What was the atmosphere surrounding it?
The atmosphere, so far as one living in Washington was concerned, was very much that it would. The law clerks talked about it at lunch, and it wasn't just the Supreme Court arguments in the case that received press coverage. The arguments before Judge Pine in the district court were front page news in the Washington papers, perhaps not elsewhere.
And did you and your fellow law clerks have any prediction what would be the final outcome when it worked its way through the Supreme Court?
Oh, I don't think most of us knew what position our justices would take. We did have a vote at lunch one day, and I think, as I recall, we were evenly divided, but that was not on the basis of what we thought our justices would do, because most of us didn't know.
And what do you remember most vividly about the oral argument? I believe it was May 12th of 1952.
Well, the fact that John W. Davis argued for over an hour and I think was asked only one question. I mean, he had a style of advocacy that you don't hear nowadays, but it was very impressive. And then Solicitor General Perlman got a whole bunch of questions from the court.
And Arthur Goldberg participated as well?
Yes, he participated in oral argument for the AFL-CIO, I believe.
Right, for the steelworkers, yes. And in your book on the Supreme Court, you tell a wonderful story about the Justices' Conference that Friday, at which they voted on the case in private. What do you remember about that?
Well, as I say, of course, the clerks weren't present at the conference, but George Niebank, my co-clerk, and I were just as dying to find out what happened, as I suspect all the other clerks were too. So we followed Justice Jackson into his office when he got back, just as we always did, and he would tell us what happened at the conference. And he said, "Well, boys, the president got licked."
And Justice Jackson's concurring opinion in the steel seizure case is generally regarded by constitutional scholars as the most significant. What did he say about presidential powers, and why did he write separately?
Well, I think he wrote separately because almost everybody did write separately. I think the opinions had to be prepared in a fairly short time, and I think even those who agreed with Justice Black's outcome felt that there needed to be more said about the thing. And Justice Jackson's concurring opinion classified presidential power in three different ways. First, where he was acting with the approval of Congress, and there Jackson said, only if the whole government is disabled does he lose. Second, where he's acting without congressional authorization, but without congressional disapproval, and there it's kind of a middle ground. And finally, what Jackson felt had happened in the steel seizure case, where he was acting in an area where Congress said, don't do what you want to do, do something else. And there he said the power is at its nadir.
Right. And did public opinion, do you think, influence the court's ultimate decision that President Truman had exceeded his constitutional power?
I think it did. The government made some extraordinary claims at the very beginning in the district court that the president had all the authority that George III had unless it was taken from him by the Constitution. Well, you can imagine the press outcry about this. I mean, it just made headlines. And it just gave a negative aspect. The government abandoned that argument long before it got to the Supreme Court, but it just got the government off on the wrong foot.
And there was an ambivalence about the Korean War even at that point, wasn't there?
Very much so. There were people fighting and dying in Korea, but very few sacrifices called for on the home front. World War I, or rather World War II, I'm not that old. World War II, you had 14 million people under arms, but a lot of things restricted on the home front. The Korean War, you just didn't have those restrictions on the home front, so there was just a real ambivalence, as you say.
Yes. And what would you say is the lasting significance of the steel seizure case as we look back in constitutional history 50 years?
Well, I think the subsequent opinions of the court have adopted Justice Jackson's concurrence, and that kind of trifurcation is probably its contribution. I think people have expressed the view that had it come up in time of declared war, it might have come out differently. And so, it's just one of many cases in this area, but I think the Jackson concurrence has been pretty much what it stood for.
And I'm reminded that one of the great things about a retrospective like this is it allows us to learn history from key people who actually participated in it. So your recollections are particularly relevant and meaningful, and it puts us in a good position now to step back a half century and examine a presidential decision that's really largely been lost to history books and law books, but is still highly relevant. So thank you very much, Chief Justice Rehnquist, for introducing today's program.
It's been a pleasure to be here, Professor Gormley.
Thank you. But Chief Justice Rehnquist, many of you know, at that time was a young 27-year-old law clerk to Justice Robert Jackson. And he was the law clerk at the time the steel seizure case was decided. Reading between the lines, I think he helped draft that decision for Justice Jackson. Simple point that Chief Justice Rehnquist made in that video. By the time this case got to the Supreme Court, there really wasn't a sense in this country that we were at risk. Fighting in Korea had come to a lull. People in the United States were more worried about this battle between the New York Yankees and the Brooklyn Dodgers that summer than they were about this steel seizure issue. And so there was a sense that these dire military warnings by Secretary Lovett and others were just very much overblown. Jackson went on to say in his concurrence so eloquently, presidential power was at its high point in this theater of war. Presidential power, the president's power, is at its high point on the field of battle in foreign lands. It's at its lowest ebb on American turf, especially when the president has acted without congressional or constitutional support. So applying these lessons to the Bush wiretap program, I argued that the Bush administration's gathering up of phone calls and emails bumped up against the Constitution in a number of ways and failed to survive that collision. It's problematic enough when the executive branch does an end run around Congress and bypasses this legislative scheme that was specifically put in place for just this type of domestic surveillance, the FISA law. But the problems only multiply tenfold in a situation like this, where the chief executive actions collide with fundamental rights of citizens and with U.S. residents under the Bill of Rights, specifically in this case under the Fourth Amendment that requires a neutral and detached magistrate to give a warrant, usually. In such a case, the president's power is at rock bottom. In fact, it arguably falls, and I argued this to Senator Specter and others, it arguably falls in a category even lower than President Truman in the steel seizure case, because we now have these individual rights that are potentially being lost. There's no question, ladies and gentlemen, that President Truman believed passionately in 1952 that his actions were necessary to protect American troops, to protect soldiers in Korea, to safeguard the nation. There's no question in my mind that President George W. Bush believed fervently that the warrantless surveillance of certain communications by citizens or residents in the United States was necessary to carry out his administration's daunting war on terror. Yet, as Senator Specter aptly stated during the give and take of the hearings, this doesn't provide a blank check to any president. Congress and the courts, in fact, have a duty to correct the situation, have a duty to step in and stop the president if the executive branch commits an error in assessing its own powers. It may be true that in the immediate aftermath of the aggression of 9/11, the president's powers take on a real heightened importance, even on the in America on the domestic front. But unless we're prepared to say that a president can just suspend the Constitution by making a unilateral decision that there is some kind of an emergency, unless we're prepared to say that, we cannot permit a president to make those kinds of decisions by himself or herself. And there is nothing weak or activist at all about the other branches of government stepping in to stop it. In fact, that's what we call checks and balances. That's what we have. Our entire system of our rule of law depends upon that, and our country collapses if we don't have that. What we've learned from experience is that times of crisis are usually when we make the worst decisions in hindsight. And that's true not just in America, but in any country. In America, the fear of communists and socialists during the First and Second World Wars led to prosecutions under the Espionage Act that in hindsight really drastically, improperly curtailed First Amendment freedoms. Attorney General Palmer's roundup and arrest of thousands of suspects in 1919 and 1920 during World War I who were allegedly part of a communist plot to overthrow the government, which never panned out, was viewed later as a disgrace. Many of you are very familiar with the panic after the Japanese invasion of Pearl Harbor that led to the internment of 100,000 American citizens. And these were American citizens of Japanese descent on the West Coast, moved to these camps in the middle of the country. And the infamous Korematsu case that I think the Jackson Center also did a program on, that was later vilified, and the Solicitor General of the United States publicly apologized and remunerations were paid to those families. So times of crisis are when we make the biggest mistakes. On the other hand, there are real reasons for doing these things. President Lincoln was criticized repeatedly for suspending writs of habeas corpus during the Civil War, arguably in violation of the Constitution. He would say, well, I'm not sure what good this Constitution is going to be for us if we don't have a country anymore. The fascinating thing, I think, ladies and gentlemen, about being alive at a time like this, it's a complex, fascinating, complex, admittedly dangerous time in our country's history, is that we get a direct view into the minds of public servants, great public servants like Robert H.Jackson, who have taken steps to prevent overreaching during times of crisis for the sake of preserving this democracy. Our fear of terrorism in the United States today may prove to be accurate. It may prove to be greatly exaggerated, and we aren't going to know for probably quite a long time until the web of history is finally woven. But without remaining true to the dictates of our Constitution, we can be certain that we will lose more than we'll gain. One of the great things about having the privilege of lecturing in a setting like this to celebrate the life of a great American jurist born here in Warren County over a century ago is that we still are in the midst of a debate on this subject. And the beautiful part, as far as I'm concerned, is that ultimately, in another 5 years, 10 years, 20 years, as a result of thoughtful public discourse, including gatherings like this. As a result of that, the courts and Congress and our presidents will figure out among themselves how much power is appropriately wielded by each branch and to what extent each may have crossed over the line in dealing with the aftermath of the events of 9/11 in a way that prevents and actually threatens the long-term stability of our democratic experiment. So it isn't all black and white, just like Justice Jackson's test. It's all grays. And Justice Robert Jackson, with brilliant foresight, taught us how to make sense of this blurry spectrum when it comes to presidential power. He also taught us, I think, ultimately, that it isn't the president or Congress or even the Supreme Court of the United States that will ultimately decide how far each branch of government can go in a great democracy like ours. Rather, ultimately, it is us as citizens who will make that call. Thank you so much for the privilege of being here in this beautiful courthouse with you tonight.
Robert Jackson, on the other hand, was a product of the public schools of Frewsburg and Jamestown, New York, never attended college, and was essentially self-taught in the law, having matriculated but 1 year at Albany Law School and apprenticed in his cousin's law office. Whereas Robert Jackson spent his first 20 years in the law as a county seat lawyer in general practice in rural Jamestown. It's these aspects of Justice Jackson's background which hold special resonance for those of us who were raised in small towns, educated in the public school system, and practiced law in our county seats. Of course, we know the path of Justice Jackson's career when he left his practice in Jamestown to enter government service at the request of his longtime friend, President Franklin Delano Roosevelt, General Counsel of the U.S. Treasury Department's Bureau of Internal Revenue, Assistant Attorney General in charge of the Tax Division of the Justice Department, Assistant Attorney General in charge of the Antitrust Division, Solicitor General, Attorney General, Justice of the United States Supreme Court, and America's chief counsel at the Nuremberg war trials. During these years, there were very few major decisions of the Roosevelt administration in which Robert Jackson's counsel was not sought. But this evening, I would like to focus on a dilemma which presented itself to Justice Jackson toward the end of his career and his all too short life, in the form of the landmark case of Brown versus Board of Education. But to place this account in perspective, I first need to say a few words about the work of constitutional interpretation and Justice Jackson's judicial philosophy. Now, Justice Jackson was certainly no stranger to politics of the partisan variety. As Professor John Barrett recently reminded us in one of his periodic Jackson List posts, Robert Jackson was interested in and connected with democratic politics for his entire life. In his youth, he spoke and worked in Chautauqua County for presidential candidate Woodrow Wilson, and later served for a time as county chairman. He became active in New York State Democratic politics and worked actively for Franklin Roosevelt's elections as New York governor in 1928 and 1930, and his presidential elections in 1932 and thereafter. During Jackson's Washington service in the Roosevelt administration, he interacted with and befriended the politicians involved in the national government, although he, of course, ultimately decided against seeking elective office himself. Aside from democratic politics, however, Jackson was a student of the American constitutional system, serving as he did in both the executive and judicial branches. He was well schooled in the design of the framers and believed strongly in the necessary separation of power and responsibility among the three departments of government. Jackson understood politics in yet a third sense. Based upon his life's experiences, foremost his many years of practice in the county seat of Jamestown, he had acquired, as Professor Kronman put it, a wisdom about human beings in their tangled affairs. As Jackson said in his famous ode to the county seat lawyer, such a man understands the structure of society and how its groups interlock and interact, because he lives in a community so small that he can keep it all in view. On July 11th, 1941, Robert Jackson was sworn in as an Associate Justice of the United States Supreme Court, on which he served until his death in 1954, except for the leave of absence to represent the United States at the International Military Tribunal in Nuremberg. During his tenure on the court, he settled into an approach to judging, which legal academics would describe as one of judicial restraint, a philosophy which was most aligned with that of his closest friend and colleague on the court, Justice Felix Frankfurter. Justice Jackson envisioned a limited role for the court in resolving the claims of aggrieved parties, believing that in a democracy, civil liberties could truly be protected only by the will of the people and not by 9 appointed judges. He espoused a vision of federalism that weighed heavily on the side of state prerogatives. He tended to protect the rights of the community against the constitutional claims of disaffected individuals. Although Justice Jackson referred to the Constitution as a blueprint, a foundation upon which the constitutional structure is to be built to meet the exigencies of the times, he had a great respect for the weight of precedent and the role of stare decisis in terms of the settled expectations of the people, and he thus generally disfavored overruling precedent. He understood the enforcement limitations of the judicial branch, mirroring Alexander Hamilton's oft-quoted passage from the Federalist number 78, in which Hamilton wrote that the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them, as the judiciary has no influence over either the sword or the purse, and thus may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Justice Jackson was wary of judicial supremacy, not only because he thought it inconsistent with democracy, but because he felt that unenforceable judicial decrees bred public cynicism. Finally, Jackson, like Frankfurter, thought that judges were obliged to separate their personal views from the law. So let's come now to the Brown case. Brown versus Board of Education was argued twice on the merits, first in the 1952 term of the Supreme Court and again in 1953. Throughout the Brown arguments and conferences, Justice Jackson was concerned with the question of how a proper opinion striking down segregation could be written, and was equally troubled by the issue of how such a decision could be enforced. Professor Laura Ray has distilled his dilemma. Jackson's performance in the Brown saga reveals with unusual clarity a justice struggling to reconcile his political and judicial divisions, privately convinced of the rightness of desegregation, Jackson worked to ground the court's result not in his own policy preference, but in the terra firma of legal doctrine. But I also believe that were he with us this evening, he would readily agree that the conflict which he experienced in Brown was well captured by his friend, Felix Frankfurter. Judges, wrote Justice Frankfurter, are called upon for allegiance to nothing except the effort, amid tangled words and limited insights, to find the path through precedent, through policy, through history, to the best judgment that fallible creatures can reach in the most difficult of all tasks, the achievement of justice between man and man, between man and state, through reason called law.
Great pleasure to be here. This, once again, I sense my hero, Robert Jackson, standing next to me. It still gives me chills to tell you this, is that when the Chief Judge turned to me and said, "Mr. Prosecutor, your opening statement." And this is a moment where a prosecutor isn't telling the judges what took place. They kind of have a sense of what has happened. I mean, obviously, they didn't fall off the turnip truck, plus there's a lot of motion practice going on. So they have a sense. What you do in an opening statement, and I'm sure Robert Jackson did the same thing, is you want to tell a story to the people of the world of why we are here, why we are doing this. And also, and this is just as important, in fact, very important, you are the voice of the victims of the horror that took place in Europe or in West Africa. It doesn't matter, because the pain and suffering is just the same. And so you have an obligation to seek justice and to tell the world their story, because they have disappeared into the sands of time. And so when you walk up to that podium, it looks just like this, and you open your statement and you put your hands just like this. I actually felt the great man's hand on my left shoulder as I began. Your Honors, good morning. And then I began to give my opening statement.
On a special applause to the press of Mr. David Green, presents his opening statement.
May it please this chamber, Your Honors, on this solemn occasion, mankind is once again assembled before an international tribunal to begin the sober and steady climb upwards toward the towering summit of justice. The path will be strewn with the bones of the dead, the moans of the mutilated, the cries of agony of the tortured, echoing down into the valley of death below. Horrors beyond the imagination will slide into this hallowed hall as this trek upward comes to a most certain and just conclusion.
So I just want to leave you with that thought, because again, the spirit of Robert Jackson continues. It started here, literally, physically, in Warren County, Pennsylvania, but it worked its way through up north to Jamestown, New York, and then spread towards Albany, and then down to Washington, D.C. He was a remarkable man. He was, in my mind, the quintessential American lawyer. He is why we become lawyers. He is why we cherish the law. He is why we are American. Here he is, Warren County, Jamestown, New York, and he becomes the Solicitor General, the Attorney General of the United States. And one would probably say that's pretty good. I'll take it. But then he becomes an Associate Justice of the Supreme Court of the United States. And then to the detriment of his career, because he is concerned about this, because what he wants to be, and you've read the history, he wants to become the Chief Justice of the United States. And he was actually pretty much the front runner. And yet, he was called upon by Harry Truman to become the chief American prosecutor at the International Military Tribunal at Nuremberg. That's a special moment, because I had that special moment as well. International criminal case, not only is it there's no glamour to it, and there's nothing mythical about it, it's just good, solid lawyering. All right? The same kind of law that you learned in criminal law, all right? The same things you see on television. You got facts, you got law, you got elements of a crime, and you start proving it one element at a time. The evidence. And he also was talking, well, what happened to you? And he's describing how his hands were cut off. And he looks over at the defendants, and he points his stub, and he goes, "You did this to me." And to see those leadership of the RUF drop their eyes in shame, that's justice. Isn't it? That's justice. This little man from a little place somewhere up north in Sierra Leone, whose family is no longer with him, he's missing both his hands, and to sit there and look at these individuals who are the battle group commanders of the RUF and point to them and look them straight in the eye and say, "You did this to me," and watch their faces drop. I'm thinking, you know, I suddenly realize why I'm here. And that's why Robert Jackson felt in various times why he was here and his wonderful team. They were all convicted as charged and are serving sentences between 45 to 52 years. And you're thinking, what? Did you just... I mean, we put frankly, we put to death someone who kills one human being. But these are individuals who killed tens of thousands and did various things to it. Well, at the international level, as an aside, there's no death penalty. So they're sentenced to whatever the trier of fact feels, and they can appeal it, of course, to the appellate chamber. And I'll talk a little bit about the organization just quickly in a minute. But it's hard time. There's no such thing as parole, time off for good behavior, clemency, or what have you. Once the appellate chamber reviews it, make sure that it's appropriate, they are sentenced. And so 52 years is 52 years. There it is. Justice is done. So all of these individuals are prosecuted and found guilty. Now, one of the things that I wanted to leave with the Sierra Leonean people throughout all this process, okay, and then with all this dust swirling around and with all this pain and suffering, with all of the challenges my people had, their health, their families, just living to the end of the day security-wise. One of the things, or the three things I told the people of Sierra Leone I wanted them to understand, and that is the law is fair, no one is above the law, and the rule of law, that's three, is more powerful than the rule of the gun. Just remember those three things. And this is the legacy that Robert Jackson left us. The law, the courage, the way forward, the bright and shining light. And as Henry King maybe even did here, because he did it a lot, he'd pound the table. The spirit of Nuremberg lives. And I'm here to tell you, folks, the spirit of Nuremberg lives. I'll finish up, and then whatever time they allow me to be with you, I'll tell you the story. I walked the countryside, like I said, and there was a particular school in Freetown itself that I visited quarterly. And it was the Milton Margai School of the Blind. And they were a wonderful group, and I visited them for 3 years. Of course, Uncle Dave, as they called me, would always bring Coke and candies and stuff like that. And we would sit there, and I'd pass it out, and they'd be munching away and drinking Cokes. You know, they're blind, but they certainly like candy. But they had also a wonderful choir that actually sang for the Queen of England in Westminster Abbey. But
we're talking. Hey, how are you doing? How are things? Have you been reading about the special court or hearing about the special court? How do you think we're doing? I mean, these are just kids between about 7 years old to about 18. And we talk for about 45 minutes or so. And the last time I went to visit him, it was just a couple days before I left in June of 2005. I visited him to say goodbye. And so we, excuse me, we did our thing, and then the headmaster said, we have to say goodbye to Uncle Dave. And they said goodbye, and then they all stood up and they sang a song. Excuse me, I've never done this before like this. They sang a beautiful song called It's a Small World After All. So with that, I leave you with my thoughts about the spirit of Nuremberg. It does live, and it lives today. Thank you very much.
But it's Robert Jackson's birthday, and he's the one who should be receiving all the presents, I guess, but he's really our gift. He's the gift to us. He is a gift to Warren County. He's a gift to the world, and we're really here to celebrate his major accomplishments. We have to admit that we did not know much about Robert Jackson when Greg Peterson called us a few years ago, and I mentioned this earlier, to say, have I got a story for you? We were heading down I-79 on the way to do some interviews for our Harry Keller magician documentary, and Greg called and he had seen our Ida Tarbell documentary on public television. He said, I've got this great story, you're going to love it. But we didn't know much about Robert Jackson. We'd heard of the Nuremberg trial, but that's about it. And here we are, ourselves from Western Pennsylvania. And so we just read all we could. We just jumped right in, and we decided, even though we weren't in a position to take on a new project right then and there, you cannot say no to Greg Peterson. I don't know how many of you know Greg personally, but I think you will agree, you cannot say no. He is so passionate about Robert Jackson and sharing his legacy and his story, and the Jackson Center itself and its 10 years of wonderful service to, again, not only our local community, but to making this story available to the world is very important, and we congratulate Greg and his board of directors for doing such a fantastic job. Like Greg, over the years we've come to appreciate the significance of Robert Jackson's achievements and why we have so much to learn from him. Jackson's speeches, his Supreme Court opinions, his work at the Nuremberg trial, and even the trajectory of his life story. The fact that he came from a small community in the middle of the forest, which we absolutely love this region ourselves, but I mean, when you think about it, it's a very small town. He didn't go to college, and that really, I think, speaks to young people today, that you can go on and do these great things. And it doesn't matter if you live in New York City or LA or Chicago, you can come from a place like this, surrounded by beauty, and go on to do some wonderful things. Producing a documentary like this is really like going on a treasure hunt, and really that's what it's like for me. And you just find some interesting stories in the most unusual places. We're still turning up new information about Robert Jackson. I was just talking tonight at the reception about some new people who can shed light on his story. And it's really amazing that the treasure hunt has taken us to some pretty wonderful places. It's taken us in the footsteps of Robert Jackson to Spring Creek Township. We went looking for his family homestead along Broken Straw Creek, and Rich will tell you at the time we were experimenting with a new large format HD camera. So we're lugging all this big equipment through the woods. But we were determined to find where he lived and to look at the horse farm that he loved so well and that he returned to. Years and years, he would keep coming back here. We wanted to know what it was about this region that he came to love. So part of that treasure hunt took us in his footsteps. And we also traveled to the Library of Congress, where there are 280 boxes of his personal papers and family photographs and letters and his opinions. And we only had, a week? We've been there twice, but it's nowhere near enough time to explore all this wonderful material that's there. That's where his personal papers are, but there's also an awful lot of material at the Robert Jackson Center, and we've spent time there. We shot exterior scenes at the Supreme Court. We got permission to shoot there, and I think there's a lot of, we had to go through a lot of hoops to do that because of all the national security issues and everything with terrorism, but they allowed us to come in and shoot some scenes there that you'll see in our opening segment tonight. We attended the International Humanitarian Law Dialogues that Greg alluded to a few minutes ago, and how many years has that been going on now? Is that 5 years? 5 years. And we had the rare opportunity to listen in on some of the conversations of these chief prosecutors of military and criminal tribunals all over the world, and to hear the challenges that they face in prosecuting the most evil crimes against humanity and genocide that you can imagine. And you heard David Crane, if some of you were here last year, you heard some of those stories. But to be able to go to Chautauqua Institution and sit on the porch, Rich, remember, I mean, we sat in the rocking chairs the evening before the presentations and heard them talk among themselves and talk about Robert Jackson and the international law, and they really look at what he established as the beginnings of international law. But to sit there and hear them talk, it was a very rare and wonderful experience to be able to listen in on that and then interview some of these people for our documentary. And for the bonus features, I don't want to call it, it doesn't sound right to say that, but on the DVD that we release, we will have some of these really special interviews about the experiences today to show the connection between the Nuremberg legacy and what's going on today. But these people were very tired and very weary, and still they persisted, using the rule of law that Robert Jackson established and the others at the Nuremberg trial, and later the subsequent actions of the United Nations and the International Criminal Court. And that will always stay with me. I guess when you start on a project like this and you go out on this treasure hunt, you never know what's going to come back, but it tends to stay with you. So if you have an opportunity at the end of August, to go to the International Humanitarian Law Dialogues, it's public, it's free, it's open to the public, and you can sit in the audience and hear these kinds of discussions at the end of the Chautauqua season, and it's so close to us. You really should go if you have the chance. We've really, in addition to that, we've combed private and public collections for hundreds and hundreds of photographs that are needed for visual material to tell this story. The Harry Truman Library, the Robert Jackson Center, and I hope Jen Champ is here. She is just such a huge help to us in the archives at the Jackson Center, because they have been the recipient of many collections. The Henry King collection is there now, and wonderful photographs from people like Ray DiDario. We also have permission to use images from the United States Holocaust Memorial Museum and Library. And some of my favorite people are librarians and archivists, because they love when you give them a challenge and say, I'm looking to tell this story, and can you help me find a photo such and such from 1941? They just love that, and they will go and help you, and even on short notice, we've had wonderful response from people who are willing to help with this project, and many of them know of Robert Jackson, and so they're even more thrilled to help. We're fortunate to be able to build upon the work of U.S. Army photographer Ray DiDario, who documented Nuremberg, the Nuremberg trial, and Nuremberg, the city, after World War II. And maybe some of you have seen his work. Have you seen his work at the Robert Jackson Center? It's a beautiful exhibit of his photography there. Of the defendants, but also of the trial and of Nuremberg. And a lot of this is also on the Jackson Center website for you to see. But anyway, I had the chance to meet Ray DiDario when he was here, and also to talk with him by phone before he died not too long ago. And in preparation for this presentation tonight, I again used Google to say, I wanted to find a little bit more background about him, because I knew that he had died. Well, when I brought up his New York Times obituary, would you believe that Ray DiDario, who documented the Nuremberg trial, whose photos you're going to see in this sequence, died exactly 1 year ago today, on Robert Jackson's birthday? That, to me, is just very moving. And in talking with Ray DiDario by phone, he, like Jackson, said that this was the most meaningful work of his life. Hoping will come as a result of this documentary, and maybe if we can engage young people in this whole idea, was Abraham Lincoln was leaving church one Wednesday evening, and he was asked what he thought about the minister's sermon. And the minister, he said, well, the minister had a strong voice and a good delivery, but he forgot the most important part. He forgot to ask us to do something great, to leave and go out into the world and really do something great. And I, again, look out over this audience, and today earlier with the young people at Warren High School, I think there's a lot of hope and there's a lot of possibility here for everyone to make a gift to the world as Robert Jackson did. Thank you.
And I appreciate all of you coming tonight to hear a little bit about my experiences. And as you all know, Robert H. Jackson is in any respect, by any definition, the father of modern international criminal law. And I had the great pleasure of being part of that legacy for the last 10 years from the point I went down to Sierra Leone. It was Nuremberg, and quite something new coming into Nuremberg, in that we're going to take those leaders of this vanquished country and we're going to apply the rule of law to the things that they did. But it created a new way to deal with these kinds of actions and what went on and what came out of World War II. And as I said, that's the legacy that I have been honored to be a part of from the time I went down to Sierra Leone. These are 8 of the 10 that we took to trial. 1 of the 10 died between the end of natural causes. He had surgery and complications from surgery due to a health issue. They're serving their sentences ranging from 15 years to 52 years. And believe it or not, they're serving those sentences in Rwanda. We were the first court to bring down international convictions for the use of child soldiers against those we charged. The International Criminal Court has brought down, have many charged with it, and has indeed since that time had 1 conviction on the use of child soldiers. The other thing that caught the world's attention in Sierra Leone, and this hadn't gone on in other places in the world, at least not to the calculated way it did in Sierra Leone, was that the rebels in Sierra Leone, of course, wanted to seize control of Sierra Leone. They wanted to seize control of the government and the people, but that was all about gaining access to the resources of Sierra Leone and the power that came along with those resources. They engaged in a systematic campaign of amputations. They amputated limbs from people. It was known as you can have a short sleeve or a long sleeve. They amputated their limbs off by the thousands in Sierra Leone. Let's spend a little bit of time that we have talking about Charles Taylor. Shortly after we indicted him, but after we unsealed the indictment, he was forced out of power by rebels within his country. He was essentially doing to his own country what he was doing to the neighboring countries. And essentially groups within his country forced him out of his country. He went into exile in Nigeria. The biggest part of trying these people is getting them in your hands. And without the support of the international community, you can't. Charles Taylor went to Nigeria. And he was in exile in Nigeria for almost 3 years. Finally, the international pressure was overwhelming against Nigeria. And Nigeria finally came on board and said that we will release him. We will return him to Liberia. We won't turn him over to the Special Court for Sierra Leone, but we'll return him to Liberia if indeed the newly elected government in Liberia asks for him. A lot of behind-the-scenes negotiation took place, and eventually that government did indeed ask him. Now it's put Nigeria on the spot. This, of course, is the picture I like much better, because this is a little later when indeed we did have him in the dock, and he was indeed sitting in our courtroom at his initial appearance, is what this is. But at any rate, Nigeria did agree to return him to Liberia, because the newly elected president, he asked for his release, and Charles Taylor suddenly disappeared. He was suddenly gone, missing from his place of exile in Nigeria. Charles Taylor was captured. He was indeed put on a presidential jet and flown to Liberia. This is Charles Taylor sitting in the helicopter or on the way between Monrovia, Liberia to Sierra Leone. Well, one of them landed with Charles Taylor. Charles Taylor got out, He was escorted from the helicopter about 100 yards to our detention facility. After that moment, we may have tipped one or two, I don't really recall, but we may have had a cause to celebrate just a little bit. This is the team that indeed went into the initial appearance of Charles Taylor. He came into our custody in March of 2006. June, we transferred him to The Hague. Unfortunately, it took another year and a half before the trial actually begun in Charles Taylor's case. Charles Taylor trial lasted for 13 months. We presented the evidence of 100 witnesses. 94 of those witnesses we brought to court. We never alleged that Charles Taylor set foot in Sierra Leone. He pulled the strings from next door in Liberia. How did he do that? We ultimately convicted him of aiding and abetting, supplying, and planning what went on in Sierra Leone is what we ultimately convicted him of. But he did all of that from Liberia. So how do we prove that those crimes took, when we have witnesses, victims, that never saw Charles Taylor? They knew he was responsible. Well, in many instances, we had insiders come in and testify. Many of them came to, we of course gained many more witnesses when Charles Taylor was arrested and in our custody, because then, quite frankly, they weren't afraid of him anymore and they were more willing to come forward and testify. The defense case lasted for 16 months. We did 100 witnesses in 13 months. They did 21 witnesses in 16 months. Charles Taylor testified for 7 months. If you look over Charles Taylor's right shoulder, or on our left of Charles Taylor, you'll see someone sitting there in a white blouse. That's my wife, Pam, right over there. Naomi Campbell, that's right. But the reason we brought them to testify was, I told you earlier how Charles Taylor was supplying weapons to the rebel forces. And remember how I told you that diamonds were being used to fund those weapons purchases. Naomi Campbell was in, I'll make this story very, very quick, but Naomi Campbell was in South Africa at a dinner being hosted by Nelson Mandela. At this dinner, believe it or not, Charles Taylor, who was then the president of Liberia, basically crashed this dinner party. And later, two men showed up at the guest house that Naomi Campbell and Mia Farrow were staying in and gave Mia Farrow what she described as this small package of dirty-looking pebbles. We were able to tie Charles Taylor into first having raw uncut diamonds, which he had claimed he never ever had, so we caught him in a lie. But that visit to South Africa, putting diamonds in his possession, coincided with a weapons shipment. I hate to see it takes Naomi Campbell to get the news there and to cover the trial. The bottom line is they did come and cover the trial. And included in that coverage was a lot of footage and a lot of reporting, background reporting on what had happened in Sierra Leone. And so it brought this terrible conflict and these terrible atrocities back into the spotlight and back into the world spotlight. We convicted Charles Taylor on all 11 counts that we had charged him with. Very, very successful conviction, and he was sentenced to 50 years in jail. He will most likely serve his sentence in the United Kingdom. That we had leaders and that we were trying to hold them responsible. This had never happened in Africa before, certainly. Not at this level, not trying a head of state. You just don't prosecute African heads of state. They go into exile and they remain there in their last years. And in fact, that's head of states all over the world that has committed these crimes. It's not just in Africa. But this shows that it was indeed happening. I don't think that the international tribunals will ever adopt the death penalty. I don't.
Presentation by an incredible individual under incredible circumstances. I am just thrilled, Jim, that to make this presentation on the 121st Robert H. Jackson birthday, because it is a direct legacy of what Justice Jackson did in Warren to what you did, your services. And you must know that these are real humanitarians. The lawyers who commit their lives to conducting and prosecuting international humanitarian law are cut above most other lawyers. Other lawyers, excuse me, but sorry guys, I don't care. But, yeah.